Contractor sued us for an extra $15 but ended up owing us $5. Welcome back to Reddit Court Files, where we pull real stories from Reddit and put them on trial. Today's case comes from r/legaladvice. Quick note, nothing in this video is legal advice. We're storytellers, not lawyers. Now, let's get into it. In Florida, a homeowner was ready for a fresh start. They'd found a contractor, highly recommended, to completely redo their bathroom and part of their bedroom. The discussions were thorough, albeit verbal, and one thing was crystal clear. The contract was the contract. No surprise bills at the end. They'd gone above and beyond, supplying almost everything themselves: flooring, fixtures, fans, even accounting for overages from wasted materials. The contract itself was basic, just a list of jobs like replace tub, redo flooring, with a total at the bottom. Simple, or so they thought. The job, initially estimated at a swift 4 to 6 weeks, dragged on for 3 excruciating months and was still incomplete. The contractor started weeks late, and on day 1, his dumpster driver managed to drive into the neighbor's yard, leaving ruts and sparking an admittedly overblown but immediate scandal with the new neighbors. The bedroom floors were installed incorrectly, yet the contractor insisted it was how all his customers prefer it, and a more high-scale pattern. There were tons of little quality issues they constantly had to point out. While the bathroom wasn't falling apart, it was full of long-term questions, especially concerning expensive fixes like plumbing and flooring. Then, just as they believed they were on the cusp of the contractor's final visit to install some glass and call the job done, a text message arrived. It was about overages, a bill amounting to about 1/3 of the total cost, thousands of dollars. And the list? Almost entirely things already agreed upon or clearly within the original scope. He quoted $1,000 to oil the floors, a process that's part of the install, even trying to use a different brand oil against their explicit instructions and desired look. He'd even claimed the oil they wanted wasn't available, forcing them to buy it themselves. Other line items included expertise, because he claimed things they asked for were more difficult. One example. Their exhaust fan was a single large unit in the attic, ducted to both the water closet and over the shower, with a single vent up. Our homeowner, no contractor themselves, thought a single unit with a single switch sounded easier than installing 2 separate ones. They were just trying to be done and move on, but this was a bridge too far. Our homeowner adamantly objected to the charges, but, desperate to simply conclude the nightmare, offered a small sum just to get the final step done. Their belief was firm. Any potential lawsuit would be governed strictly by the contract, or lack thereof. And given how broad and general that signed contract was, they felt strongly that the contractor had no legal grounds to pursue more money without clear addendums or prior agreements. The crucial point was that he had never mentioned any extras, difficulties, or anything of the sort during the work. It was all no problem. They hadn't added or changed a single thing. Internally, they knew they could have pursued him for the messed up floors, trying to get him to pay for a proper redo, but the thought of more headache and delay was unbearable. They just wanted this contractor out of their lives. So instead of going on the offensive, they made plans to reach out for a professional legal consult, hoping to calm their nerves and hear that they had nothing to worry about. They admitted that they had learned a tough lesson about not having a more specific scope of work signed, having mistakenly thought a different, more detailed quote had been the one they agreed to. After seeking clarity and validation, our homeowner found solid ground. Their instinct was correct. The general contract, while initially a source of anxiety, actually provided significant protection against the contractor's last-minute demands. Without written addendums, signed change orders, or even contemporaneous documentation of these alleged overages and increased expertise costs, the contractor's claims held little legal weight. The fact that the homeowner hadn't added or changed the scope of work, and the contractor had always said no problem during the job, fortified their position. They weren't just guessing, they had a strong case. When confronted with these basic facts, the contractor, without a leg to stand on, eventually backed down, realizing he couldn't legally enforce a bill for unapproved, undocumented charges. The homeowner successfully negotiated his final departure, finally putting an end to the protracted ordeal without paying a dime of the bogus overages. Turns out, even a basic contract, when adhered to and not amended, can be a homeowner's most powerful shield against contractor overreach and attempts at a surprise cash grab. That's the verdict on today's case. Drop your thoughts in the comments. Was justice served? Make sure to subscribe so you never miss a filing.